I want you to think about something that sounds deeply unfair. One, your company receives a tax assessment. You go ahead, you fight it. In between, you negotiate a settlement through alternative dispute resolution with KRA. You agree on a number and pay. But then, once you finish that discussion about the company, KRA comes for you personally as the director of the company. And once they come, they demand a tax on the same money, the same transaction, the same income that you have just settled on the other end with them as part of alternative dispute resolution. So you get two bills for the same pot of money. For many small and medium business owners in Kenya, the line between themselves and their company on the other side is a very thin and blurry line. They usually withdraw money from the company account, they pay suppliers, you cover transport, and you use that to manage operations. And if you're one of these companies, you need to reach out to us because the case we are going to discuss now will show you the kind of risk that you are running. Because when KRA audits the company and finds this withdrawal was coming from the bank, they're going to assess the company. But then they can also turn around and assess you as the director personally for the same withdrawals as undeclared income. But remember, you are taking this money to be able to go out and pay. And the result will be the same amount of money potentially being taxed twice. One for the company and one in your hands. Now let's get to the case. Joseph Thuo was a director of the company you could have heard of it, Mahiga Homes Limited. This was a construction company that was based in Nairobi. In February 2020, he received a personal tax assessment of 10 million from KRA. So when we were all struggling with COVID, Thuo was having it worse. KRA's position was that during the year 2018, Joseph had withdrawn a total of around 28.9 million from the company's account, but had not accounted for that money or accounted for it properly. Joseph's explanation was that all these withdrawals had gone to pay the company suppliers via M-Pesa and to cover things like transportation cost and payment for the materials. Because remember, he's in construction. Problem was, Joseph had no documentation to prove it. To even make the situation more complicated, Mahiga Homes itself was at the same time under investigation by KRA for the same transactions that Joseph was being investigated on. So Joseph was facing a personal demand and his company was facing a corporate demand on this other hand. When it rains, it pours. But Joseph wasn't about to go down. He objected to the personal assessment and the company as well objected to the corporate assessment. And this was communicated to KRA. But on 5th May 2020, the commissioner confirmed the original assessment that they had provided. So Joseph was supposed to provide some 10 million to KRA for his failure to produce documentary evidence. He had no invoices, he had no receipts. Joseph couldn't agree. So he filed an appeal at, you guessed it right, the Tax Appeal Tribunal. Meanwhile, on the other hand, Mahiga Homes had also appealed its corporate assessment. Remember I said KRA was trying to tax two people, same amount of income. But for Mahiga Homes, instead of going to court, they didn't want to go to a full hearing. So KRA and the company entered into an alternative dispute resolution, which is where you sit on a table and negotiate. And for them, on April 21, 2021, they signed an agreement for the amount that they were supposed to pay. But here is where the story gets really interesting. The settlement that was signed by the company specifically named Joseph Ruhiu Thuo. It detailed all the 28.9 million withdrawals that had been deducted through M-Pesa and which was being assessed on him. And once all that was done, it had been arrived that the company owed a pay liability of around 5 million, which, because it's payee, it was supposed to be paid by the company. So the company's total revised tax for the year 2018, and this covers income tax, pay, and withholding tax, was agreed to be 14 million. According to Joseph, he believed that that matter was closed because in the agreement with the company, he had been specifically named in that settlement agreement, and it was the same amount of money that was being discussed. But the commissioner wasn't done with him. He was chasing him personally for the money. Now, When Joseph tried to use that alternative dispute resolution agreement in his personal tribunal case, KRA objected to that and objected strongly. Now, Joseph raised a preliminary objection, argued that the original objection in 2010 was invalid under Section 51, subsection 3 of the Tax Procedures Act, because that objection had not stated the precise grounds and he had not attached any supporting documentation. If the objection was invalid, then the tribunal had no jurisdiction at all to hear that appeal. So that was KRA's argument. But Joseph's lawyer had a powerful response to that. Let's pick another section. Now, under Section 51, subsection 4 of the Tax Procedures Act, if a commissioner believes that an objection is invalid, he must notify the taxpayer in writing within 14 days. But KRA never did this. KRA had issued an objection decision confirming the assessment. And if you don't understand, this is what you do when an objection is valid. So what the commissioner did only raised the validity question much later, which seems like an afterthought. And they only did this when appeal was already at the tribunal. And this is very unfair because you cannot wait for months and then start claiming that the objection was invalid. The 14-day window that KRA has been provided for by law had long passed. And because of this, the tribunal agreed and dismissed the preliminary objection from KRA. I know right now you are lost, but this is because you shouldn't be trying to understand all this. You should be coming to me for a consultation. But let me explain. What the tribunal then did is they examined the alternative dispute resolution settlement, I'll call it a DR, from the Mahiga Homes case and found that the figures that are being contested now are identical to the same figures that are in the ADR. The settlement had dealt with the same income, the same withdrawals, and the same transactions. Now, to allow KRA to demand tax from Joseph and from the company would be very unfair and would amount to double taxation. And because of this, Joseph's personal appeal was declared as spent. The assessment that was being claimed from KRA was set aside. Now, this is KRA. They have time, they have resources, they have lawyer. So, as a sole loser, KRA wasn't happy. They went home and decided not to take the loss lying down. KRA didn't sleep that day. Instead of letting people heal from the COVID-19 pandemic, they appealed to the High Court. But the Lord of Joseph was also not sleeping. This is the same God who saved Joseph from Herod, or whoever the king was, or I don't know, Potiphar. I don't know who Joseph was saved from when he was having those dreams, but that God came through for Joseph. They represented their case. Justice Okwani upheld the tribunal's decision entirely. She noted that KRA's complaint about the missing documents was a question of fact, not a question of law. And the High Court can only hear an appeal coming from the tribunal to address questions of law and not questions of fact. And in this case, there was no error in law. And because of this, the appeal by KRA was dismissed. And here's the lesson for you. If you are running a company and that company enters into a settlement with KRA, go ahead and read that settlement agreement very carefully before signing it. If you have a personal grudge with KRA or KRA is coming for you, if that ADR specifically names you as a director and it's the same transactions being handled all through, you need to make sure there is no double taxation that is coming from that assessment. But that protection works if the ADR has specifically mentioned you when it was being drafted. In the next video, I'm going to tell you about a shopping mall that received a tax assessment of 386 million. Once they got it, they filed a proper objection and then waited and waited for nearly 2 years. And when the commissioner finally responded, remember, this is nearly 2 years after the objection was filed, the mall lawyers just said one thing that stopped the whole case on its tracks. And the High Court agreed with those lawyers. Sometimes in tax disputes, the most powerful argument is not about the numbers, but it could be a matter of law. So watch that case next.